interest. And subsection 2, nothing contained or done under any authority shall be inconsistent with or in contravention of this section as in the Constitution, provided that that law in question makes provision that is reasonably required in the interest of public safety, public order, and B, that is reasonably required for the purpose of protecting the rights or freedoms of other persons, and except so far as that provision, or as the case may be, the thing done under the authority thereof is shown not to be reasonably justifiable in a democratic society. Finally, section 12, a person shall not be deprived of his freedom of movement. That is to say, the right to move freely throughout Dominica. Nothing contained in or done under the authority of any law shall be held to be consistent with or in contravention of this section. A, for the imposition of restrictions on the movement or residence within Dominica of any person that are reasonably required in the interest of public safety or order, and B, for the imposition of restrictions on the movement of residents within Dominica or on the right to leave Dominica of persons generally or any class of persons in the interest of public safety or public order, except so far as that provision, or as the case may be, the thing done under the authority thereof is shown not to be reasonably justifiable in a democratic society. Now, I would submit that the interesting and important facts to note from those four sections of the Constitution is that having established quite clearly that there are rights and freedoms that individuals have, it goes on to say that those rights and freedoms in certain circumstances are constrained or abrogated by whether or not the thing is reasonably required, and whether or not it is in the interest of public safety or public order, and thirdly, whether or not the thing is the actual thing is reasonably justifiable in a democratic society. And so, when we look at the Riot Act, despite its dated language, when one breaks down the language of what it is saying, I would submit that it is saying that where actions, behaviors occur which are unlawful, because one has to recognize that it doesn't say any gathering or any gathering. Section 4 doesn't say any gathering you can go in and do X. So neither Section 6. It ties the action of the state, of the law enforcement authorities, to only being able to act, arrest, apprehend, use the language that is in the Act, if the behaviors and actions of those gathered is unlawful. Well, I guess I hope we'll address that in a moment. So, looking at the opposition arguments, I am aware of the others, but these are the ones that I have blocked out. First is the argument that it's unconstitutional. Well, I think I've already been indicated that for the reasons I've indicated, that that is not so. Indeed, Section 2 of the Constitution, which deals with the right to life, which I ought to probably have had with me, but I don't, because of not a wardrobe malpractice or malfunction, but printer malfunction, which was left me using the print this gadget, but I think I can find it very quickly. Without losing too much time. Section 2, subsection 2. Section 2, a person shall not be regarded as having made it wrong. I should say that Section 2 deals with protection of the right to life. It says a person shall not be deprived of his life intentionally, save in execution of the sentence of a court in respect of criminal offense under the law of Dominica, of which he has been convicted. Subsection 2 says, so obviously, if you kill somebody, other than on that type of justification, you'll either charge him with or some other offense in the ordinary course Section 2 says, a person shall not be regarded as having been deprived of his life in contravention of this section if he dies as a result of the use, to such extent, in such circumstances as are permitted by law, of such force as is reasonably justifiable. And it has A, which is the defense, B, in order to effect a lawful arrest, and C, for the purpose of suppressing a riot, insurrection, or mutiny. So, I submit that the Constitution is not at odds or at variance with Section 6 of the Riot Act. But what is clear from Section 2 of the Constitution, as indeed from Section 6, is that any such action would have to be justifiably or reasonably justified, and that's a matter of facts and evidence, essentially. And as indeed subsection 2 says, having been deprived of his life in contravention of this section, if he dies as a result of the use to such extent and in such circumstances as may be permitted by law. So Section 6 permits certain actions, I would submit, but at the same time, subsection 2 is clear that those actions would have to be deemed reasonable, reasonably justifiable. So it's not in my submission. I don't want the language based on its vintage may be understood by some to be carte blanche. I'm not sure, and in fact I doubt that courts will interpret it in that broad manner. But I don't know. I'm not aware of any cases that have been litigated in that area. So when that happens, we will probably have a clearer, or I should say, an authoritative view or opinion. Another criticism is that it is a threat to civil liberties. And again, my rebuttal to that is that the Act in and of itself as provisions cannot be a threat to civil liberties, because there's nothing in the Riot Act that says you're not allowed to protest. One has a right to protest, but there are certain laws which are enacted that need to be followed. So, for example, if you need to get permission so as to protest, then that has to be followed, as is quite clear from the Constitution. Even if you are protesting in a particular area, and that's the area that you're permitted to protest, then that's where you need to be. In terms of the behaviors, generally speaking, if you are in a peaceful protest, I do not see how a peaceful protest, and I'm not peaceful, not because I say it's peaceful, but it's actually peaceful. We all know it's peaceful in reality. And peaceful is what it is. When you see it, you know it. Just like when you see something that's not peaceful, you know it's not peaceful. Burning tires in the road and blocking the road and throwing stones is not peaceful, not in my book. So I reject the threat to civil liberties because I do not accept, and I would contend forcefully, that the Act does not prevent. There are people who walk. I mean, we know there are various walks in Dominica. People walk on certain days of the week. People have walked around certain buildings, walking around Jericho and so on and so forth. And they were not prevented from walking or doing whatever they want to do. The only times where there have been any kind of pushback that resulted in any kind of conflict is when people have gone perhaps a little further. Sometimes sexual words, I guess, and sometimes people believe they have a very strong issue. We're human beings, and if we feel very strongly, very passionately about something, sometimes we may act in a way that we might not otherwise do, especially if we're in a group situation. So that's probably the explanation. So the fact that the third point is that sometimes people allege that it's a colonial relic, and that really we should dispense with that old stuff from back in the colonial days. That there is some substance to that. It is certainly, as a matter of fact, it's colonial, it's dated, it's aged. So I don't take issue with that. What I say, however, is that there are many pieces of legislation on our books that are dated, some even more dated than that, and we don't necessarily challenge them. The Poetry Act and a whole set of are older in terms of age. So I think it's more about whether or not the Act captures what is relevant for society today. That argument may be a different argument, but I don't think just the language or the age of it necessarily makes it not fit for purpose. Fourthly, it is contended that it is misused to repress political opposition, well, that's similar to the civil liberties argument. Fifthly, that it encourages the use of disproportionate force, and I suspect that perhaps is linked to the Section 6 that I read out. But again, I say evidence has not demonstrated that in the Dominica context. Maybe in other contexts, but I am not aware of that being demonstrated in the Dominica context. But I'm aware of actions, blockages, even the proclamation being read out, and for many hours after, people have not dispersed. So that I don't think it applies to Dominica. And then finally, the use of vague terms and definitions, where we spoke about that already, so I'm not going to go over it. Arguments, the pushback really is to say that, as we said, the Constitution is, the Act is not in conflict with the Constitution for the reasons I've stated and others. The Riot Act is necessary to regulate and control serious disorder, destabilization, and threats to national security. I don't think anybody can seriously argue that it doesn't have that characteristic to it. It's necessary. I think most people would accept you have to have some kind of legislative framework which guides the law enforcement authorities and indeed those of us in society, so we know what we can do, what we're allowed to do legally, and what we cannot do legally or lawfully, and I think that this is reflected in these provisions. I think I touched on other points whilst I was dealing with it. Maybe I should just say this as well. One of the things I said is that the UK has repealed its Riot Act. As I said, that goes back to 1714. And that was repealed by the UK in 1973. But one of the things, the difference is, I would submit, is that law was repealed because it became, I don't want to say obsolete, but certainly it was no longer fit for purpose. In the 70s, and it continued into the 80s, but certainly in the early 70s, around the 73 time, that through the 70s, there was a social upheaval in the United Kingdom. Riots, Brixton riots, you may have heard of those. Riots in Nottingham, other areas. There was the strikes. And one of the things that was very significant is the football hooliganism. That, again, you may have heard of it, but it's that football games where thousands of people go to games, and there was it was almost like a disease, I guess, but young men sometimes have to find mischief, and the different segments of the fans of different clubs used to deliberately arrange for fights, these huge fights, and these things would be running battles through the streets of various towns and cities. Of young men fighting bottles, knives, etc. I mean, fortunately, England doesn't have the firearm prevalence that the US has, but certainly violent people getting seriously hurt and even killed was a regular, almost a weekly event at games. And so the combination of those factors drove the UK to the conclusion that the Riot Act was not appropriate for the circumstance. And if you think about it, it makes sense. Remember, what I read from Section 4 and Section 6 of the Riot Act. Under the Riot Act, you have to, at some point, the authorities have to decide this thing is serious, and we have to read proclamation. The proclamation has to be read properly. If it's not read properly, you have a problem. Read it properly. But most significantly for the purpose of what I'm saying now, is you have to make that proclamation. Well, if you're in a ruling situation, like I've described with gang warfare and stuff, making a proclamation is probably not the best way of trying to deal and control that situation. Having made the proclamation, which is probably even worse, you then have to wait at least an hour before you can act on that proclamation. Now, if you've got a serious situation and fluid situation, then it's probably challenging to do that. That is probably something that's more useful and more readily applicable to where you have a fairly contained situation. So you have a protest which is fairly contained, there's 500, there's 1,000, there's 5,000 people, but in a fairly contained area. And maybe you can read a proclamation, you can wait for an hour to allow people to disperse, people to go. These are the factors that I suggest impacting the unity. So what, for example, so now you will find the Riot Act, the Riot Act, the offense of riot, you will now find it in the Public Order Act in the UK. And there are other jurisdictions that have that as well, including within our region, Prime Minister, for example. And so the Riot Act is now Section 1 of the 1986 Public Order Act in the UK. Violent disorder is Section 2. 3 is Section 3. And I think harassment is probably Section 4. But the reality is that those offences are still recognized as serious offences, and they carry serious penalties with them. So I would submit that the argument that one needs to get rid of the old zoning legislation and bring in new modern legislation may well be necessary. So, ladies and gentlemen, my time is up. I suspect I may have overrun my time. I hope I haven't done it too much. So, as I said, I support the Riot Act. Thank you very much.
Thank you, Honorable Attorney General. And the Attorney General is right. We are here to determine and decide the events to judgment that occurred. But the events earlier this year was what brought about this forum tonight. So it's important you consider these individuals so that it's a discussion. It's not a case before the court where we're going to determine the outcome here. It's simply their discussion when they wish to present on these issues. So we thank you, Honorable Attorney General. Now we move to Mr. Clement Joseph, the attorney for the deputy or the director of public prosecution and Chief of Barbuda. But before that, I believe I missed Mr. Julian DeFoe, is the Minister of State in the Agricultural Global Economy. Is that correct?
That's correct.
I'm not a good politician.
That's correct.
If you're a farmer, I'll see you out there. So maybe we'll see. Okay, I don't know if Mr. Joseph, if you're...
Mr. President, I don't know if you can hear me clearly. Thank you. I'll start off by saying good evening to all and those listening and watching. And I think this is an important discussion that we can have as Dominicans in relation to these two pieces of legislation. In my role, official role as Director of Public Prosecutions, my duty is to enforce and prosecute the laws of the jurisdiction in which I'm in. Antigua and Barbuda has the same wording of this legislation, the Riot Act, the Public Order Act, as does Dominica. If called upon to prosecute, then I am duty bound to do so. That is my official part. I'll tell you my personal part about this legislation. And number one, I think that it has outlived its usefulness in a democratic society. In the case of, the Honorable Attorney General spoke about derogation of rights that you can pass a law. The Constitution gives that power, that if a law is passed for public safety, etc., that they can abridge those rights by legislation. However, in the case of the Freitas and the Permanent Secretary of Ministry of Fisheries, for want of a better description of that law, where Mr. De Freitas was an employee in the Ministry of Agriculture, and he went out to protest what he called corruption of the Minister of Agriculture. And they moved him to try to, under the Civil Service Act, say that he did not partake in political activity. Took the matter to court, and Justin Simon represented him before the Privy Council. The Privy Council set the 3-test standard to decide whether a law is constitutional or not. Number one, do we have a problem in society that needs to be addressed? The government is to answer that question. The answer is yes. We move on to the second question. Is the law rationally connected to that problem? The government needs to answer that. If they say yes, then you move on to the third question. Is it proportional to the problem that it seeks to control? The answer is yes. Then the law could be deemed to be constitutional. However, the Privy Council used that case in many common law jurisdictions to test the constitutionality of the breach of rights, and developed that case in subsequent cases and added a fourth requirement, that if the government could answer all 3 questions, the claimant, that citizen, if he can show that that law is not okay in a democratic society, then the law could fail. Mr. De Freitas showed that the government could not prove that it was proportional, because joining the government civil service could not take away your political rights as a citizen. So that law failed, and they struck down that part of that Civil Service Act or regulations that prevented that. Let's take a look at the Public Order Act. The Public Order Act, sorry, the Riot Act, 1897. In the 1800s, we saw the liberation of slaves. And what we got was a rush of laws to contain them. That was the reason of all these laws. Go to the Small Charges Act of any of the Caribbean islands. You cannot dance in the street. Loitering. If you're charged 3 times for loitering, you can be deemed a rogue and vagabond. All these types of things were to control free slaves and to prevent them from enjoying themselves. And I got this argument from a professor at UWI. I have adopted it, and I believe that is what it was meant for. It is unfortunate that the sons and daughters of free slaves have taken the reins of government, and no one has seen it right to repeal those legislation and give citizens the freedom that the Constitution has intended to impose on its citizens. If you go to the Riot Act, you will see that there was only, under sections 4, 5, and 6, there was only one amendment to the Riot Act in Dominica, and it was passed in 1974. I don't know what exactly was changed, but as Dominicans, we know of one piece of act, that a notorious act, that was enacted in 1974 in Dominica. And for those of us who don't know, I will help you. It was called the Dread Act. it wasn't the term in the Dread Act, but it was some other official name. And you heard the Honorable Attorney General refer to Section 6 that talks about if you help the police to contain these rioters and you kill them, you maim them, you hurt them, you are indemnified from punishment. And that was the language in the Dread Act. Anytime you kill a dread, you are indemnified from punishment. And we know that was repealed as soon as the interim government took power in 1979. That was one of the first acts they repealed, the Dread Act. So why do we still have language similar to the Dread Act in laws in the Commonwealth of Dominica? The Riot Act tells us that the person or persons, well, no, it doesn't say the person, it says the persons who remain, you have to remain for 1 hour after the proclamation in order to be liable under the offense. We've seen a lot of people charged in Dominica, and on those complaints, one of the complaints that you did from 12:01 p.m. to 1:02 p.m. It doesn't have that on it. And they are charged individually. So if I am charged individually for a certain set of hours, and the other people you're talking about that are charged, and they were not there during that period, I could not be counted as one of the 12 if I am charging. Now,
it's free to discuss. It's free to discuss.
is there a defense counsel saying something here?
They're not trying to matter.
It should be on the talking generality.
I am speaking in general.
Okay, I mean, the intention was, of course, to discuss. Well, no, there's the Riot Act, yes, and the Constitution, and your rights and civil liberties. It wasn't about the case specific.
What you're saying is that they have charges at the level against people, and they are missing certain things that things should be.
Members of the Prosecutorial Bar Association, I regret to announce that exit stage left.
We don't want to look at the complaints.
I'm going to leave this discussion.
So Mr. Joseph, we don't want to.
I sincerely apologize. I apologize to the Dominica Bar Association.
If I may, Mr. Joseph, the Honorable AG is simply raising the point that if at all, if it is that you are addressing the particulars of the case before the court, that may not be probable. Probably you could just clarify whether that is what you are doing or not.
I am saying that the wording of the Act calls for persons to remain 1 hour after the proclamation. That's the law. Some Jews say that, that's the law. Again?
Not disputing that.
Okay. It calls that persons must be in numbers of 12 after the proclamation has been read. It appears that the law and then my contribution for the evening. Thank you.
Yes, and of course we want to caution that we're not dealing, as we said, we clarified, it's dealing, as the Honorable AG said, we're just dealing with the opinion on the Act and the Constitution, etc. But we're not dealing with the event specifically or the charges against individuals or what they say. So it's looking at dissecting and discussing opinion with regard to the laws complex and their applications in general. Okay, now we welcome Mr. Geoffrey Latham, defense attorney, to the podium.
Good evening, distinguished colleagues, members of the community, Justice Roberts, ministers of government, members of the public and the media. Let me first make the declaration that I will not be commenting on this recent matter which are involved. I want to thank the Attorney General and the DPP, that is Clarence Joseph, for the insightful thoughts of the Riot Act and their perspective as state governance and prosecutorial arm. But as defense counsel, I would take it from a different level. I would look at individual citizens and the humanitarian and constitutional standpoints as it relates to the Riot Act. Now, the mere fact that we gather here tonight, this campus, is reflective of a space or an environment that encourages dialogue. Isn't that so? Intellectual freedom, isn't that so? And the democratic ideas. And ask the critical question, is the Riot Act necessary in a democratic society? Well, permit me to rephrase it. And I think the proper question that should be asked is whether the Riot Act is reasonably justifiable in a democratic society. And the heart of this question, I want us to understand, lies as how we as a nation define our relationship with power, with protest, and public space. So my role tonight, Mr. Moderator, is to show how this Riot Act impacts ordinary people. Even the lawyers themselves. Because you know, Murdoch, some time ago, they had a protest with the lawyers. They were protesting against the condition of the court. It was 12 or more. And they marched up to the ministry. I was part of that. Activists. How this act impacts on activists or religious group, even in peaceful marches. Those people could find themselves being branded unlawful simply because of assembling together, even in silence. And so we must ask the question tonight, that does the law make rooms for peaceful dissent? Does it safeguard against abuse? And most importantly, does it reflect the values of modern rights, respecting democracy? So my question again, is the Riot Act necessary in a democratic society? Is it reasonably justifiable? The answer, my answer to that is no. Me too. You said yes it is, I said no. And the reason why I say no No, it's because in its current state, in its current draft state on statute book, it is not reasonable, necessary in a democratic society. Why? AG, because it violates constitutional rights. It lacks proportional safeguard. And I will define that as I go along. It's for me to do so. And also it is incompatible with modern humanitarian and democratic standards. I basically couch the Riot Act of Dominica as a blanket ban act. Now, let's look at some overview of the legislative instruments. And I will start first with the Riot Act. Earlier, the Attorney General made reference of certain provisions of the Riot Act. Those provisions authorizes a magistrate, justice of the peace, and even a senior police officer to disperse a group of 12 or more people that they deem to be unlawful, they deem to be riotously or tumultuous incident. Now, the Act does not define the term unlawful. Neither does it define the term AG riotously or tumultuously. And I notice you never defined that to the crowd tonight. Why AG? Because the Act does not define it. And as a consequence, what it does is thereby allow a broad and subjective interpretation by the enforcement officers. Let's talk about that proclamation. Yes, the Act authorized a reading of a formal proclamation demanding dispersal. And that if the group fails to disperse within 1 hour, force may lawfully be used even if it results in injury or death. That can be lawful. And the reason again, section 6 of the Act says that it provides for legal immunity. And I think Clement Joseph was mentioned it a while ago. So that any person acting, any police officer acting for the suppression of a riot is exempted from criminal liability, civil liability, even in cases where that person is seriously injured or dead. Can that be constitutional? But if you never go to section 11 of the Constitution, you mention section 2. You never touch section 11. You can ignore it. Right? Section 11 of the Constitution provides or protects the right to freedom of assembly and association. It permits restriction only if needed. It permits restriction only if they are reasonably justifiable in a democratic society. I want to underscore that. That same constitution that the AG read, it provides for restriction only if it is reasonable and it is necessary in the circumstance. So let's examine some of the key points of the constitutional inconsistency of the Riot Act and also the humanitarian deficiency of it. first point I want to highlight here is that it is disproportionate. Because why? It involves the use of automatic force. And the kind of force we are talking about it is lethal force. Firearm. Shooting people. If that crowd is not dispersed after 1 hour, think of it. Think of it. I made my opening remark some time ago, 1 or 2 years ago. I think Heather Felix was there. We were part of that group, the lawyers. Madam President Roberts, you're the one who led that, right? You were the president then? That's right. It was 12 or more, 15 of us thereabout. And we peacefully walked up to the ministry. The Riot Act says that we can deem to be unlawfully gathered. Is that fair? And if the police comes and give a proclamation and say, look, lawyers get up from there, or else. And within 1 hour, the lawyers decide they are not getting up from there. They fire shot in the process. Get injured. Is that proportionate? Think of it. Think of it. So, you have a peaceful crowd of protesters that exceed 12 or more people, but may be subject to force without engaging in any violent behavior. Persons will just come across as onlookers, not realizing that there was some proclamation passed an hour ago. Think of it. You just get good. And here it is, you fall victim. The police officer right there is one of those training designers for it. He's right at the back. I pointed to any direction. And he's watching me and he's shaking his head. Later he's writing. And I will tell you, folks, why again, the Riot Act conflicts with Section 11 of the Constitution. Because Section 11 of the Constitution requires that limitations or restrictions on assembly must be reasonable, must be necessary and proportionate. In those little examples that I gave you, it cannot be said that the Riot Act is reasonable or is necessary in a democratic society like Dominica. Be honest. Take notes each. I think it's something that we can look at. Now let's look at the jurisprudence. Let's look at the jurisprudence and how the courts view this. I put up this case, McCann versus United Kingdom. That's a 1995 case, and it came up before the European Courts of Human Rights. I knew what the court ruled. It says that the use of lethal force by the state agent must be strictly proportionate to the threat posed. We have a police act here in Dominica. And the Police Act says to the police, your duty is to protect life and property. This these days I see police every part, they walking in town, they have a gun and a rifle with them. No, that's a nice one. It's be yourself. The whole purpose of that police act is to have that kind of public and police relationship. Their first role is to protect life, not to shoot at people in case of a riot, not to use tear gas in case of a riot. And that's what we examined there. So this case, the court says, look, if you're going to use lethal force, boy, be careful. Must be strictly proportionate to the threats being posed. I mean, we have to be fair to the police. Sometimes there might be a situation where if their life is in imminent danger, and not only police officers, ordinary citizens. Exactly. The law provides that you can kill someone, you know. Because it says murder is the unlawful killing without legal justification or excuse. So you can kill someone, but your excuse must be justified. Also, the UN Basic Principle on the Use of Force and Firearms 1990s made the statement that force must be used only as a last resort and lethal force only when strictly unavoidable to protect life. So obviously if you're at your home and someone comes and attack you for cutlass or something, murder, you can protect yourself. You don't have to wait to get the last blow. So if it means you have to put the man down, you put him down.
We went people are magic, you know.
Well, let's move on. I want to wind this up. Again, the Riot Act, another point I want to emphasize here, it criminalized peaceful assembly. And you know how? Because it does not distinguish between peaceful gathering and a violent crowd, riotously, tumultuously assembly. As I said, there could be 12, 13, 40, maybe 50 people gathered. Some might be violent, but some might be peaceful. Just look us. But once you're part of that, you are deemed to be a criminal under the Riot Act. Just imagine there is a very silent protest, a prayer vigil, candle vigil, 12, 13, 40 more people walking and praying, praising God. Police say, what? They have more than 12 there? Let's discuss that. They can apply the Riot Act. So, the issue is that under those principles that are cited, the Riot Act is not reasonably justifiable. A lot has to be done to it. Another area that I want to look at is that it lacks judicial oversight and safeguards. There is no mechanism for judicial oversight, no duty to review the proclamation, no rights of appeal of those who are affected under the Riot Act. When the police give a proclamation, who's going to review that? Really? The Act doesn't reach. Not under the Riot Act. Proclamation. Again, I want to emphasize the point here that there is a colonial legacy that is incompatible with modern democratic standard. Okay, and the point was made earlier by Clement, and I agree with him. She also alluded to that. Yes, there is some colonial legacy attached to that. It is modeled after a 1715 UK Act. Again, pointing out to this, when persons, Clement mentioned that, more persons in slavery when they were being suppressed because they want to express their freedom, and so on. So that act is rooted way back and is rather outdated. So here is my conclusion and my recommendation. My conclusion is this. This colonial statute that treats assembly as a threat is not a right. Point number one. Point number two is that it's outdated because it does not reflect current international human rights standard. Number three, it is overbroad, it is too wide, applying to any group, 12 or more persons, without no regard to the purpose, no regard to the intent, no regard to conduct. Number 4, AG. It fails the constitutional test of being reasonable and proportionate under Section 11. Number 5, it fails not only our constitutional test, but international standards of necessity, minimal intrusion, and proportionality. So AG, here's my recommendation. Repeal and replace that line. Repeal and replace with modern legislation that clearly define what is a riot. What does it mean to be unlawfully assembled? And the threshold for intervention. The Act requires, when it's being repealed or replaced, I think, we should take that step. It requires independent and judicial review of the proclamation or dispersal orders. There should be mandates use of force guidelines with proportionality checks. Also, it's recommended that incorporates training in human rights and de-escalation techniques. And most importantly, please let that Riot Act comply with Dominica Constitution and international human rights obligation. And
I didn't know if I had to genuflect and say hallelujah, amen, as one of the preacher there. Yes, brother. Yes, brother, amen. You pass the collection plate now. Now we come to our final presenter, Chair Justice Adrian Minus, 1 minutes.
Acknowledge the Honorable Attorney General, honorable ministers, presidents, lawyers, friends, ladies and gentlemen. I came up here with my computer ready to speak, but I think you've had a good idea, or you've been exposed to the deficiencies and even the merits of the Riot Act. I wish I would have made an order tonight, but I wish I had gotten more fulsome, because right now I'll have to ask the AG to revert certain things that Mr. Lita has said, and I'll have to give a right of reply. but it doesn't apply tonight. The time is limited. You've heard the short and brief historical overview from Mr. Lieutenant Joseph. I'm sure most of you may not have known anything about it because most of us were born after 1974. At this point, what I would like to do is to just open up for questions and answers. And I will try my best to respond to your questions and answers. I don't think that there's anything I can add to the discourse. My personal view, my learned view, if I may so say, is that while I would not hold the whole act itself as unconstitutional, because we do not generally have to, the challenge is generally to a particular section of an act as opposed to the whole act itself. There are certain sections that, the first couple of sections which says what the penalty is for a riot, what the penalty is for an unlawful assembly. I don't see anything unconstitutional about it. So it would have to be section by section. I have issue with section 4 and 6, which all the speakers before me have mentioned. In particular, section 6, which gives an absolute immunity. And I think also Mr. Leighton have given you very good overview of that. So that particular section is one that I would advocate for repeal. And we should do something like the US, where persons would call upon the parliamentary representatives to make this kind of representations before the parliament to change legislation. Unfortunately, we as citizens of Dominica, we do not take up that role at all, to look at legislation and to advocate for certain legislation to be repealed and to be replaced. I truly believe that we need legislation to deal with public order. I mean, in any civil society, you're going to need legislation to deal with it. But the Riot Act, as it is, in the language it is framed, it leaves a lot to be desired. And in particular, Section 6 is unconstitutional. So, ladies and gentlemen, if you have any questions,
Maybe we can open that up to everyone.
if you have any questions, just raise your hand.
Yes, I think, thank you, Honorable Retired Justice. I think we've taken in general possibly for the time of questions to the whole panel, but that'd be all right. And just for you to know, even though the law is an adversarial process. You have plaintiff, you have defendant, so naturally you go into court and you're fighting for your clients. But you see, even though Mr. Leighton addressed the AG personally, they still can share a little laugh because they know they're on the spot here and they're supporting their position. It's not to fight the case, it's not to fight the case. And Mr. Joseph had very salient points, very important. He may have been caught up, but maybe he could have said, well, not really referring to the case, but I didn't know what his presentation was. Okay? And if you look at one of the sections in the Riot Act that is under great scrutiny, as it has been presented by both sides, is that section 6, and it's basically this. You look at it, you get a chance to look at it, there's 300 words approximately in that section, and there's only one full stop. There are 26 commas and one semicolon. And when you try to decipher what the subject, the verb, the predicate is, it's untenable in a sense. There's so many things. There's a lot of descriptive words, like tumultuous, violent, indemnified, etc., maiming, hurting. So it's not so easy. And yes, it could be improved upon like anything in the English language. So what we'd like to do now is open it up to the audience for questions. But we'd like you to please be pointed and brief. Don't give us another 300-word essay. Make your point, your question, or I will simply ask the person with the microphone to pass it to someone. So get your point, please, with a very direct question. Thank you. Who's first? Who would have a question first? There must be questions. They were so thorough, there's no question. Okay, there's one back there. were brief, but maybe we can look at getting a response even on your observation.
Yes.
You're not going to give us a thesis, right? No.
No, but I also know, so please don't even say.
Well, give us a first point.
Okay, but the first thing from top of my head, from all the presentations is, this matter, it goes to the heart of democracy and sovereignty. And that's the one I hear more about. Now, what I always love about being Dominican is that we are not like other Caribbean islands. We are the land of Pina, Bolivia, Mango, a land that was never fully colonized, which you all know, a land that resisted European conquest through courage, cunning, and the mountains that sheltered freedom. Our ancestors never asked permission to be free. They never sought a colonial permit to gather or to resist. Freedom for them was asserted, not requested. Yet here we are, in an independent Dominica, still bound by colonial laws that treat our people as a threat rather than as citizens. Now, Justice Roberts, I believe, yes, she had a concern, not a concern, but an observation that it was not, the entire act is not really unconstitutional. Because the Riot Act, as we were dealing earlier, was first passed in 1714 in Britain. But it was a tool of oppression, that's what it was. It allowed authorities, as we learned, to read a proclamation to a crowd, and as very well explained, that either did not disperse, force could be used, even deadly force. But the fact is, it was never about public safety. And even in our situation, it was about colonial fear. Fear of black freedom, indigenous resistance, and the power of collective voices. Now, as we also learned this evening, that in the United Kingdom, that Riot Act was repealed in 1973, yet 50 years later here in Dominica, it remains. Our colonial ghost still wanting a free nation. Then we also had the Public Order Act, which criminalizes protest without prior permission from the police or the state. Now, what I want to reflect on is, if I must ask the government's permission to protest against the government, I must get a police permit to complain about police abuse. That is absurd. It is undemocratic, and it is unconstitutional. Now, as we learned earlier from Mr. Later, Section 11 of our Constitution protects freedom of assembly. But I also want to add that Section 117 demands that all old laws conform to the Constitution. Rights are not favors. They are not granted by permits. Now, I know I heard a point raised earlier that some may say protests must be controlled for safety. Now, I want to take a little step.
You're going on.
Yeah, I know, but it's a very important topic.
So
and we have been given you all the while.
if you have a question, though, because we'd like
Yeah, I do have a few questions, but I really want to make a point here, but beg for the listeners. Because even during COVID, in the UK, as we said, the Riot Act is no more. But they have new laws they put in 2022, which is the Police Crime Sentencing and Courts Act of that same year, which gives sweeping powers to ban protests on vague grounds like noise or disruption. And we also witness across the world COVID-19 restrictions were used to criminalize peaceful gatherings, arrest activists, and silence dissent, all under the ban of public health. We also have the WHO, who now seeks to strengthen international health regulations.
I would like this, you're going on right.
I know, but
no,
I don't
but we need a response. I would like to pass the mic to somebody else. You had your time.
No, one
but
second.
you haven't the question.
We talk about the Riot Act and the Public Order Act. What's to put in context, right?
No, that's fine. You say that you sort of summarized, you gave different points, but if you need a question, I'd like to
Okay, my final point, I'm going to come to an end, but still, it's a real thing. Because as I wanted to say, the WHO has international relations. No, that can't pressure over our institutions. Public safety is important, right? You all agree to that?
I still say you're going on. The Honorable AG. For the panel, I don't know if you have any response because it was more narrative submission. Do you have anything to say, Honorable AG? Anything?
Just another contribution. Let's get a question into the question.
I see the question. What's the question? Please, prohibit the question.
Thank you very much, and good evening to everybody. And I just want to thank the conveners because this is such a rare occasion to have that kind of discussion, and I'm glad to be there. I just wanted to ask either one or all members of the panel, with regards to the Riot Act, do they see any inconsistency with what Section 117 of the Constitution says? Because the Constitution says that Section 117 says the Constitution is the supreme law of Dominica. Any other law that is inconsistent with that Constitution, that other law must stick or fall, and the Constitution must prevail. So I just wanted to find out from the panel, is there any inconsistency in the Riot Act and the Constitution? Thank you.
Can I answer that?
Yes, go ahead.
Obviously, my presentation tonight was that I do not take the view that there is conflict. But of course, you heard from the discussions that other panelists take the view that there is. That's what one would expect to know. We have different views. I can't say to you that their view is wrong. I would tell you that I argue a different argument. But if it goes in court, it may well be that the court will find in favor of them and against me. So your question about specifically about 117 says what you say, exactly. But that's what Mr. Neto was arguing, largely. I mean, he has some slight inaccuracies I don't agree with. But essentially, he was arguing that the Riot Act is in contravention of Section 11, which is the point you're making, if you're right and if he's right. And so I don't think there's what we need to understand is that what we're having is a discussion. Different views, and different people have different ideas as for different understandings of what they're reading, what the law is. And then in the absence of a definitive court ruling, you will continue to have that. Probably even if you get a definitive court ruling, you start people who say, I don't do that. That's human nature. So I'm not arguing or presenting my position here from any position of animosity or whatever. It's just simply a question. I am interpreting it a particular way, and I'm expressing it the way I understand it. Somebody else may have a different understanding or present it differently. We may agree on some points, we might not agree on others, and that's really what this is about, unless the absence of an authority decision.
And that's what's right in a just society. You're able to air each side and then well, I believe it's an impartial judiciary determine the outcome. And of course, we have High Court, we have Court of Appeal, we have CCJ, so one can overturn another. Okay, who's next on the question?
Yes, good evening. I have a question as it relates to the Constitution and freedom of movement. We are all here tonight, right? Let's take, for example, there's one road leading out of here. And some protesters decide that they want to protest, block the road. So some of you have young children home. And there is no way you can pass through that protest to get to your home. Is it unconstitutional to you? To them? Are they infringing on your rights to move freely to go to your home? Because they decide that it's their constitutional right to remain in the road and block the road? I just want to be clear, because tomorrow morning I'm going to teach my guys on to make sure they understand. Whose rights should be considered? So I know there's freedom of movement, but when does it infringe on other person's rights? Now, are we talking about one set of rights or everybody rights?
Thank you, sir. Who would like to respond? Mr. Leta?
Yeah, so if you listen to their presentation, you would have seen, in relation to the right, there must be an intent or purpose. Okay, we are saying that the Riot Act in its present form, which I clearly outline, those areas are unconstitutional and it is subject to replacement or improvement as the case may be, to bring it in conformity with a democratic society. Now, you are raising the argument that, okay, a group of people decide they want to be quite riotous and behaving in a unruly manner, etc. Well then, if that is the intent and purpose, well then there is a law in place to have this matter being dealt with by the police. What distinction we're drawing there is that if there was a group of 12 or more people who has a particular purpose, maybe a vigil, let's talk about a vigil. There was a vigil of a candlelight with 50 people. And then one or two persons come within that 50 people and start to misbehave. Are you saying the 12 or all of the persons gathered there were behaving in a riotously, tumultuously manner? So what we're saying, what we try to gather here is that the act is too wide, it's too broad. It must be more restrictive in its meaning in order that it is successfully applied. In other words, it is so broad that it gives, yeah, put this up, so right? No, that it gives law enforcement officers this kind of wide powers to do a lot of things that are not proportionate and justifiable as the case may be. All right?
Okay, next.
Sorry, may I just understand the question. To be honest with the question, to be more specific to freedom of movement as an example, but what I think the question we're talking about is that the competing, the tension between rights. In other words, I have a right to protest, so I go with my partners and I block the road with my protest. He wants to go meet his child who is at home, maybe alone and so on, or whatever he wants to do. Mother sick, whatever it is. He can't go. He's asking, as I understand it, is his right any less than mine? And I don't think it is. And these are the tensions that you have in between these things. So I wasn't really, I don't think.
Thank you. Yes. So I hear what he said, and the question I would answer him like yes, each has rights, but the fact that the rights of the person who wants to pass is being infringed by the protesters does not mean that the law itself must not be clear and very specific, because the problem I see in this age, and if you could answer that, is the lack of definition of the words of riotous, tumultuous. It makes it so subjective, because I as a police officer may think something is riotous and tumultuous, and another person may not think so. And so it is vague because of the lack of definition. It makes it very, so there's no objective standard. And that is what is happening.
I would accept that the language, and one would not be surprised based on the fact they all understand that it is integer decisions from a different time. The more you made reference to the fact that there's probably one full stop. That was common if you look at writing from that time. What I think I would say to that is, there are, for example, when you have something that says, well, we use the word reasonable quite a lot in law. It's not defined. It will be determined when the facts are presented. And I mean, for me, I think tumultuous is not defined in the Act, but you can find a definition for it in dictionaries and so on. So my understanding. My position on this is that most of these things, despite those things I've said, I would expect these issues to be decided in court.
But because it's imposing a penalty, it's almost like punitive. It's important that it is defined because it's punitive. So it has to be clear and it has to be defined. I think formal discussion into your formal presentation of stating that this Riot Act is the Riot Act is justifiable in a democratic society. This formal part of your discourse, I think, is now over. I think we will all agree that the Act has some significant deficiencies and significant things that as human beings. This is indefensible.
But that's what our company.
No, we are not on the same page. We are on the same page. Just agree. You will agree with words unlawful, riotous, what does that mean? I could have seen people together and look at them and say, let's riotous. And then say, they're riotous. I look at them and got angry and said, this is indecent. And God says, what is indecent about it? So it has to be defined.
Mr. Moderator, I think in order fairness, since the trend of the discussion was beyond my own. I would share with you part of the ways, for example, you indicated quite rightly, I believe, respectfully, that the entire act is not necessarily unconstitutional, but certain sections, certain provisions will be. As I indicated in my presentation, I said that the two sections that I read, they were the controversial sections. I am simply saying, and I understand and I hear what you're saying and others are saying, if I got the brief to defend it, I would defend it. Now, whether if what will decide what it decides. But I believe that I can argue successfully, I believe, that there are challenges. It's not straightforward language, but I would expect it to be. But I do not accept that the language that is there is not capable of being interpreted in a manner that makes sense. I may be wrong. That's fine. I may be wrong. The other thing that I've said about this, that's Mr. Bates, I'm educated by the law. So I think I should just, and I'm not very wanted to rebut everything, but I think it is important, as I read it, Section 4, this idea that the lawyers were peacefully marching could have come under this. That's nonsense. They could never come under this. They were marching peacefully. You yourself said peacefully. How are you going to activate Section 4? What is it tumultuous? What is the lawfulness? No, that's not the explanation. There's no way that those lawyers are prosecuted. Then for Section 4 to be activated, you need 12 or more people. That's one. You need whatever they're doing has to be unlawful. So okay, you may say the police can just decide that. I don't accept that, but you can say that. There also has to be disturbance of public peace. Disturbance of the public peace. That's an element of what the offense. There has to be an order. The proclamation. There has to be a proclamation of order. You have to disregard the proclamation of order. Well, if you don't hate it, you can say that. But so the idea, what I'm trying to say is this notion that that's what
I just wanted to say that, as Madam Justice stated, just disagree with me. There will be no argument. She sounded a lot like my wife. Disagree with me. I want those shoes. I want that dress. Disagree with me. We'll be peace in the matter. See, we can still have a laugh. It's a serious issue, but again, you don't have to be disagreeable, but you can argue in even a pleasant way, and they're exchanging, and you get some good laughs. So even though Mr. Layton was directing certain comments at the AG, he was still actually able to offer a rejoinder and say, that's all right, take it in. Okay. Yes, Mr. Murray.
Gentlemen and lady, Madam Honorable Former Judge. We just ruled actually on the dispute between the two lawyers there. I think generally we agree, if I understand the arguments there, that the law, and I knew it was an old law, even before the AG said it was done in the 19th century. The style of the English was very out of date. That the law is really, according to Mr. Joseph there, intended by one group of persons to control another group of persons. And therefore, the question of being precise and, you might say, just wasn't paramount in the mind of the lawmakers. And when we come to a democratic society, which Dominica is not, which the United States is not, the only country that approaches democracy actually is Switzerland, where it's ruled by the devils. We don't, what we have is actually representative government, but for the time being, we leave that at that. These laws that were passed during the colonial era were definitely intended by the rule makers, the lawmakers, to control the majority of the population who were not of the same class and group as themselves. You might have seen me write an article in the newspaper some time ago about another law of a similar sort as the Riot Act, which is, as we understood it there, very vague and leaves things very much to the discretion of the law enforcers to decide what a riot is and when a riot is occurring. Is that the earlier Act?
Hold on.
Is a similar?
Hold on, Mr. Murray, hold on. Does Mr. Joseph have a comment to make? Yes. Mr. Joseph, do you have a comment to make there, sir?
Yes, please. We're talking about this Riot Act that was handed down from the UK. They have repealed it here. They found that it was so vague, as Jeffrey said, so vague. They have repealed it. And they have made more narrow laws to conduct public behavior. And we're still here. If someone identifies controversial sections, but vows that he can successfully defend. The same gentleman is responsible, and I'm not just sub judice, so I don't want to hear you. The same gentleman who can go in there so and amend the law to make it make sense and to be more responsive to Dominica. Let us just look at the Public Order Act. In section 2, interpretation section, it says a meeting means a meeting held for the purpose of discussion of matters of public interest or for the purpose of the expression of views of such matters. And then we had the first person who was asking the question saying, I must go to the government to have a meeting to talk about them and expect to get permission. Makes no sense, ladies and gentlemen. Makes no sense. Thank you.
Is there any other questions? Okay, Mr. Ray, if you can get to a question. I know you can go on more part, but there's any question.
I was going to finish an argument. That is to say that we have a parliament, and these laws that we've inherited ought to be all revised, and some of them should be discarded. We agree generally that there should be some kind of law to protect public order, but this Riot Act is not the correct thing for the time in the society in which we now live, where we govern ourselves. Yes, similarly, the Obia Act criminalizes, in my opinion, particular religious activity. In the United Kingdom itself, if I wish to, I could go out there and set up my sign, Obia man over here, hours from 3 o'clock in the morning to 5 in the morning.
Moving off subject.
So I'm just mentioning those two laws there because we're talking about the Riot Act. I'm just mentioning this other law. The other laws of a similar sort is our Parliament needs to go through and revise them and bring them up to date for the times in which we live and the expectations of the public as to what is legal, what is illegal, and what can be done and cannot be done. And probably that we might need to have a more activist kind of bar association that takes more cases to court on constitutional grounds.
Okay, thank you very much, Mr. Moody. Thank you very much. Any other questions?
It's a very easy question.
Mr. Ronald Jones.
Good evening to Madam Justice and of course all the speakers. Yes. I just have one simple question. I believe having regard for this discussion this evening, my question to the Attorney General is whether or not you see the majority of persons have come to the conclusion that there may be aspect of the act that is unconstitutional. Will you now go to Cabinet or go to the powers that be and say, having regard for this discussion this evening, I think we need to look at the act. Would that be considered?
I hear murmurings that he is arguing this and that. Yeah. Right? The point is, I think we need to understand, Dominic. We had made a panel discussion. I came here to present the governance side. Okay? So I don't understand why people expect me not to say what I'm saying. I'm arguing as I will be doing. So please, I mean, that's what it is. No, before I answer your question.
Oh, okay, good.
Answer your question, I think it's important that we understand. Because I hear talk about this legislation is tied to slavery and so on. Well, 1714 was introduced in the United Kingdom. I don't know there were too many slaves in the United Kingdom. So that's not the argument. The argument, we can pin the argument as something you've done to the content of the act, right? You also will find that legislation or similar was from the Commonwealth. So obviously, as we know, the Netherlands, the Caribbean, most of the countries, all of the American countries had it. Many of them, or some of them, have repealed it or changed it and done things somewhat like what people are saying here. But for example, as Trevor indicated, Antigua has exactly the same provision. I have it before me. Exactly the same provision. Exactly the same provision. Look, we are in a discussion. It's just for information. Barbados had it. At 171, we Barbados said kids have it. Exactly the same as Jamaica has it. And the other and that's not the same that is necessarily back up around. Simply saying that it's not something that is just for us, but in our jurisdiction. So the arguments that look forward would apply presumably in other places. Right. Now your question. We don't, I mean, what I can't go certain things, but what I can say to you is, I can say to you that there is draft legislation, which is in relation to the public order. So that will address probably much of what is being doing here. But that's not the point. So I'm aware of that, but we were discussing a particular thing, and I'm discussing on the point of what I believe about this particular thing. That is different from saying, so I'm not necessarily going to capitulate whatever views I have because other people are arguing in the majority. So to answer your question simply, that's not, I don't see that as a big problem.
Okay, thank you. Mr. Ito was the question.
Yes, I think there's a certain unreasonableness in the argument that what we are looking at is the Riot Act, an order, or chaos. I think it's an unreasonable argument to say that without the Riot Act, the particular approach of the Riot Act, the particular language, the particular legal approach of the Riot Act, that Dominica descends into chaos. And I think the argument has been couched in those terms. It's been a stark contrast between, do we want order, as the AG opened with his quote, or do we want disorder? But that is not really the question. I think every person in here would agree that with the amendment, the changes to the Riot Act, there are many provisions in Dominican law to ensure that we have public order and we have reasonableness in our society. So I think it is unreasonable to argue to make that stark contrast. The other thing is we have to look at the intent, and many people have said that, but I'll say it again. The intent of a particular piece of law is very clear that the intent of these laws, and even though AG was passed in England, it was because there was great classism in England, where you have many poor people and underclasses who were rising up against the aristocratic class, and that legislation was passed to ensure that these people were controlled. And so that particular legislation was then applied to the slave population, especially post-emancipation. And so the intent of that legislation has always been to control the vast majority of the people upon which it was imposed. And therefore, if that is the intent, the spirit of that legislation, we should know that that legislation cannot stand in a modern democratic society. It has to be addressed. And I know that AG is a good attorney, and he would agree that the deficiencies that were pointed out from a legal point of view are very valid, and I hope he, from a legal standpoint, that he takes that into consideration, because I believe that he believes that the allegations I don't want to take too much time. Justice Roberts said we should be more activist in asking for legislation to be changed. But when 12 or more of us do that, we have arrested. You understand? And the AG talked about peaceful protest of walking Wednesdays and no one was bothered by it. But that's not entirely accurate. Well, people are walking and talking and so on and so on. I walked and talked. At 6 p.m. one evening, 3 police officers in private clothes showed up and said, Mr. Joe, we hear you've been walking and talking on Wednesday, and I think you are about to be charged. You never did charge me. I thought I did. You realized that was probably not a good idea. But they tried to intimidate me. So the point is, with this broad stroke legislation and laws, you can weaponize those things. And that is the problem with this particular law. It is a weapon in the wrong hands, and as a democratic society, we need to ensure that these weapons are stripped away from any government. Because the government, the Constitution, should always protect the people against the government and balance those forces. And that is really what this argument is about, not order versus disorder. Thank you.
Any other questions? Yes, ma'am.
Good evening, everybody. I have sat here and I have listened. I do not claim to know anything about law, but I have a lot of common sense. And I came here as a blank slate, listening to hear how people discuss the current Riot Act and what it means for an ordinary woman like me. What I have gleaned from the discussions here this evening is that, yes, we all value law and order, and the Riot Act is not really what we need it to be, because there are deficiencies. The next thing that came to mind, however, is that I started asking myself, why do people get involved in riots? And it doesn't make sense trying to muzzle people if the things that cause them to riot are not addressed. So yes, we need amendments to the Riot Act if we decide we still want to keep it, because it's necessary for a democratic society, which I don't believe. However, the voice of the people is the voice of God, and hopefully, when people leave that their voices together can cause change, we can see change is happening. But I would also like to submit that getting a muzzle for people does not solve the issue unless we are willing to address the things that cause people to riot. Let me just remind all of us, pressure does with spite.
Any other questions? Yeah, one more? Yes, sir. Yes, good evening, everyone. Correct me if I am wrong, but reference to Riot, I observe that we are only leaning on the political side, on the political, riots that have been happening. But when it comes to Riot, you have to understand there are different riots. For example, if you're watching a football game and there's a big crowd, and the referee gives a wrong goal or something happens, a riot can also develop in that aspect. The police need to intervene. And we are not talking about those kind of riots. We're really talking about the political. What about the other riots that can develop which are not political? You understand? We're just looking at one aspect of that, which is political. Generally speaking, riots are riots, and riots can mean different things. If they give a wrong ruling, like we saw in New York with the Rodney King and so on, there were riots. You understand? How do we deal with that? Okay, Justice Roberts.
So that's why we need to change. Any riot is a riot. So it really doesn't matter what gave rise to the riot. The question is how does the act authorize the state actors, that is the police or the magistrate or justice of the peace, what is the authority given under the Riot Act, and how it is that you're going to execute that forward. What we are saying is that the Riot Act itself, if it's going to be applied at the stadium, in the circumstances that you just mentioned, that the execution of that act would be wrong. Section 6, which authorizes you, when you go to disperse the crowd, to shoot, to kill, maim, or injure with absolute immunity, is unconstitutional. It cannot stand. So if there's a riot at the stadium because of a football match, and you go there, read some proclamation, you need to start at the top of the stadium to read a proclamation, and the patrons at the stadium decide they're not going to leave, and you start now trying to disperse them, with and accompanied by civilians that you pick up based on Bath Road. So you could just go outside on Bath Road, anybody of age who appear to you to be agile, because you come and help me to arrest these people. So you just go into the stadium and start to arrest, use your gun, and start to shoot. And there's absolutely no redress for anybody the families of those who were killed, the persons who were injured, or the persons that were maimed. Absolute immunity. That is what we're saying is wrong. Section 22C of the Constitution of Dominica, that authorizes that kind of killing, said it has to be justifiable and it has to be reasonable. It cannot be reasonable and justifiable in a democratic society. That you just come into a stadium and start to kill just because you want to disperse the crowd.
Thank you very much, Mr. Burns. So we've discussed, and I think, many of us have come to our conclusions, but I'm a forward-thinking person. So what I would like to ask of the panelists, particularly the ones who are saying that the Riot Act is not constitutional or is not necessary in the form that it is, what would you propose going forward? Not just repeal and replace, but in terms of, the AG has said we need order. We need order. We cannot just have riots willy-nilly. So what would you propose in terms of a Riot Act rather than the Riot Act for dealing with that?
Any questions to the AG or to anyone?
The Riot Act was repealed. We know that the OECS always adopts acts from other countries, so we can look Public Order Act from England and see what provisions from that act that apply to us in Dublin and what it is and we're going to adopt from it. There are also pieces of legislation in other countries, not on the Riot Act itself, but under some of the public order or the criminal justice acts. And we can pick from those provisions. It's a matter of looking at other pieces of legislation. We do not have to reinvent the wheel. Let us look at other legislation, let us see how it applies, let us see whether it has been judicially challenged, and adopt the legislation. Easy.
Just a quick comment.
I would like to take that as the last comment. It's 9:30. And I would call upon Ms. Noraline Nigeria.
Just a quick comment, sir. Quick comment. Because I'm a police officer.
Now it's a minute, so you were trying to get that.
No. Because a lot of comments came towards killing and shooting. But people have to understand that in 100 and something years, nobody can put up their hand and say police killed 5 there. And in the last 20 years, there are more police officers in jail in riots than civilians. And it's a fact. No, I'm just saying that, I'm not arguing about you.
Thank you. Thank you for the and question and answer. Ms. Noraline Nigeria, President of the Dominica Bar Association.
Thankfully, I have the easiest job. Thankfully, I don't have to comment. I don't have to contribute. I have the easiest and actually the nicest job this evening, which is to thank everyone. So good evening again, everyone. I wouldn't say I would adopt the protocol. I would say good evening to the honorable ministers in our midst, our panelists, moderator, other guests, ladies and gentlemen, media, persons listening at home and everywhere. As we bring this timely and thought-provoking panel discussion to a close, it is my honor and pleasure on behalf of the Dominica Bar Association to extend heartfelt thanks to all who contributed to making this event a success. First and foremost, I extend our deepest appreciation to our distinguished panelists. Your insights into the legal, constitutional, historical, and even the social implications of the Riot Act in a democratic society were both enlightening and provocative. Can we please give them a round of applause? That whether you support it or did not support, basically what you gave, what you presented tonight, really it helped shape our perspectives and broaden our understanding of the national conversation that the Riot Act is. To our moderator, thank you for your skillful guidance of the discussion and for ensuring that the range of views was heard respectfully and clearly. We particularly thank you for keeping us engaged for the commencement of the evening. I'm sure some of us are going to go home with those lawyer jokes. I don't know why he chose lawyer jokes, but we are grateful to you, our audience, both here in person and those joining us virtually. Your interest in the topic and your engagement with thoughtful questions and comments reflect the civic awareness and commitment that are vital to the health of any democracy. Special thanks must go to our organizing committee, members of the Bar Association and the Law Week Committee, who worked behind the scenes tirelessly to plan, coordinate, and execute this event. Your dedication ensures that forums like this continue to be spaces for robust public discourse. I'm not going to name you individually, it is too many of you. I thank you personally for being ready. We of course recognize and thank our partners and sponsors. First, CG United for co-sponsoring this event with us. They are basically our co-hosts, so we really are thankful to CG United who came on board. Can we please give them a round of applause?
CG United is not a football team.
they are an insurance company and they asked me to remind everyone here, please, that they are general insurers, property insurers, people insurers, and offer professional liability insurance as well. We are thankful to UWI, who are always willing to allow us to come here free of charge because we are alumni of the University of West. We are thankful to DBS Radio and MO News, who then didn't hesitate. They came, we asked them, and they came on board carrying it live both on radio and social media. Thank you so much. So to all of our partners and sponsors, your support tonight has helped the Dominica Bar Association in fulfilling its mandate, not just to serve the legal profession, but to serve the public as well, by promoting education on legal and constitutional matters. Ladies and gentlemen, as we leave here tonight, I trust that the discussion has sparked reflection and perhaps even challenged a few assumptions. That is the very essence of a democratic engagement. It is the essence of a democracy. I say it over and over again. We need more discussions like this. This is what a democracy should be. So just to say, to thank you all once again, and to continue to support the work of the Dominica Bar Association as we strive to promote justice, uphold the rule of law, and to contribute to national development. Thank you and good night. As we thank our panelists, we have just a small token for each of you. If I could please ask Ms. Harris. Ms. Harris is the Vice President of the bar, so we will ask her to present on our program. Thank you very much. Mr. Geoffrey later.
Mr. Layton was trying to raise the barber, so it's church.
Madam Honorable Adrian Roberts. Justice Adrian Roberts. Well, I was actually going to ask people from Riot, who I included right and remarks. I did not mention people from Riot, our flutists. Yes, please. Thank you very much. So thank you very much, everyone, and have a safe journey home.
Not for him. And with that, ladies and gentlemen, we conclude another activity of Law Week. Please look out and support the other activities. And congratulations to the Dominica Bar Association for always having these very timely discussions. I think last year's discussion was about anti-corruption. And always very provocative discussions from the Dominica Bar Association. So with this, we say goodbye and thanks for viewing, everyone.